Let's get started. I call to order the FORA Reuse Authority Board of Directors regular meeting. It's Friday, September 13th at 2 o'clock. We'll be going to closed session here very shortly. Before the closed session will be about conference with legal counsel, listing existing litigation, government code 54956.9 alpha, 7 cases. First, Keep Florida Wild versus Florida Reuse Authority, case numbers M114961, M116438, and M119217. Second, Bogan versus Hulamard, case number 122980. Third, City of Seaside versus Valenzuela, case number M124499. Fourth, Florida Access Alliance versus Hulamard, case number M124709. And last but not least, the City of Marina versus Florida Reuse Authority, case number M118566. Prior to going into closed session, does any member of the public wishing to make any statements with regard to any of the items we'll be discussing in closed session? Seeing none, the public comment period's over. We're adjourning an open session. We'll meet next door in closed session. And we'll reconvene here as quickly as we possibly can. Thank you. Okay, I call the Florida Reuse Authority Board of Directors back to order. If our attorney, John Giffen, will report out from our closed session, please.
Yes, thank you. Yes, thank you, Chair. The board met in closed session with counsel, heard the arguments and the descriptions of each of the matters 1 through 7, and there's nothing to report out.
Thank you very much. I would ask if Supervisor Simone Salinas would do us the honor of leading us in the pledge.
Ready? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Simone. Okay, let's have roll call, please.
City of Carmel by the Sea, Councilmember Beach. City of Delray Oaks, Mayor Edelin.
Here.
City of Marina, Mayor Pro Tem O'Connell.
Here.
City of Marina, Councilmember Morton. City of Monterey, Mayor De La Sala. Monterey County Supervisor Salinas.
Here.
Monterey County Supervisor Parker. Monterey County Nick Chulos.
Here.
City of Pacific Grove, Mayor Camp.
Here.
City of Salinas, Mayor Gunter.
Here.
City of Sand City, Mayor Pendergrass.
Here.
City of Seaside, Mayor Rubio.
Here.
City of Seaside, Mayor Pro Tem Oglesby.
Here.
20th Congressional District, Alec Arago. 17th State Senate District, Nicole Charles. 29th State Assembly District, Erica Parker. University of California, Scott Brandt. California State University, Eduardo Ochoa. Monterey Peninsula College, Walter Tribley. Monterey Peninsula Unified School District, Dan Albert Jr. Monterey Salinas Transit, Hunter Harvath. Transportation Agency of Monterey County, Debbie Hale. United States Army Colonel Fellinger. Fort Ord BRAC Office, Bill Collins. Marina Coast Water District, Director Moore. Chair Edelin, you have a quorum.
Thank you very much. Next, we have acknowledgments, announcements, and correspondence. We'll go first to Nicole Charles. I believe she has an announcement.
Well, thank you. Last night was the last night of the legislative session, and it went very well into the morning as well. So I guess today is technically the last day. But Senator Monning's legislation, SB 232, to continue to help advance the cemetery. I'm not sure if I've talked about what it does to this group. Should I explain that?
Yeah, please.
What it would do is, since there are unreimbursed costs currently for the cemetery that were unanticipated to be that high, which is about $2.6 million. So, as you know, Senator Monning and Assemblymember Stone worked to get a budget allocation for a loan to the cemetery of $1.5 million. This legislation seeks to turn that loan into just a $1 million appropriation to the cemetery. It passed last night at 11 p.m. off of the Senate floor with a vote of 38-0. So now it heads to the governor's desk, and he has 30 days to sign it.
Fantastic. Thank you. Another announcement too. Debbie Hale and I just came back from the California Transportation Commission meeting down south, and it was announced there, I guess as of last night, we were hoping to get some reform of CEQA, the California Environmental Quality Act, that adds huge costs to not only the transportation projects we have throughout Monterey County, but everything we do. There's a CEQA component to it between EIRs, lawsuits, counter lawsuits, and reams of paper that go to nothing as far as, but that was killed. Evidently last night any CEQA reform was killed, and they're looking at bringing it back next year, so that is sort of bad news. I believe Dr. Eduardo Ochoa has an announcement to make. Dr. Ochoa has been a very active member of our Program Reassessment Advisory Committee, done a great job, offered CHUMB facilities and support for what we're trying to do with regard to the reassessment. Dr. Ochoa? Yes.
Yes, CSUMB is going to, in collaboration with FORA, is going to be hosting a colloquium on issues related to Fort Ord, including economic development, base reuse, and other types of issues. And we have we're working on a date. It's going to be in December. We've managed to push it back to December. It's going to be a 2-day event, and it's going to be open to the public, but we're especially interested in engaging all of the communities that have decision-making power in FORA and their staff, so that we can help create a common knowledge base among all of the people that are currently involved in this process, so that we can operate in terms of our decision-making from a shared vision of what we want this community to become in the next 20 years.
Thank you, sir. And we do appreciate your direct involvement and CSUMB's assistance in this. It's very, very helpful. Victoria Beach also had an announcement to make with regard to the PRAC.
Is this on? Oh, here we go. Is it on now? I would just add that we're very grateful to the university for hosting this building of knowledge. It's a very appropriate role for the university. And I also wanted to say that I'm very excited about how it's developing, especially because I think, as someone who's new to elected office, I've now had the chance to see what it's like to serve on a number of boards. And I don't think that there's a board out there in this region that has a more exciting charge, actually, than the FORA board. This is the most creative opportunity that this whole community has in the entire region, and if not beyond. And the idea that we can come together, some people know that I'm an architect. This is like getting a commission to build a dream house, except that it's for all of us to do together. So I really am so appreciative that we're going to have this colloquium to get these sort of educate ourselves about how that process could work. And I know that we're a bunch of new people here. Not everyone has the length of experience as some of the folks who've been around for a while. And just get everybody on the same page and then start rolling up our sleeves and getting going. So I'm very, very thrilled at how it's advancing. Thank you.
Thank you, Victoria. Okay, that's it for acknowledgments. Next, we have the consent agenda. There are 2 items on the consent
Chair,
agenda.
I'm sorry,
Yes,
I have an
I'm sorry.
announcement.
Please, I'm sorry.
On your desk, you'll see a handout regarding the Fort Ord Community Relations Program. We're going to be holding a tour on September 21st.
Okay.
We do this twice a year. It's a very popular event. All the technical experts on the Army's cleanup program will be there to answer questions. We do 2 90-minute tours. This particular meeting is actually going to be on the Army's cleanup of munitions and explosives of concern, as well as discussions about our burn program.
Okay, thank you. Any other member of the board have any announcements? Seeing none, okay. Again, thank you very much. Next consent agenda, we have 2 items, 7A and 7B. Any member of the board wish to pull any items for discussion?
Yes.
Okay.
Item 7B, please.
Any other members of the board wish to pull any items? Okay. Any members of the public wish to pull any items for questions or discussion? Okay, let's go back one by one. Start with 7A. Gail?
So, appearing on the second page, number 7A, you have Christine Diorio identified with the City of Seaside. That should read City of Marina.
Okay, very good. Any other corrections to 7A or comments from the board, from the public? Let's go ahead and have a vote for 7A first. We'll be voting to accept the approval of the August 9th, 2013 board meeting minutes. All in favor, signify by saying aye. Or do I have, first of all, a motion to approve?
A motion to approve
Okay,
with
sorry.
that one change.
With the one change. Okay, do we have a
I would
second?
make that motion.
Gail Morton makes the primary motion. A second? Okay, Mayor Camp. Any discussion? All in favor, signify by saying aye.
Aye.
Anybody opposed? Motion carries. Okay, for 7B, Frank, you had a question on that or comment?
Now, just very briefly, I'm opposed to entering into this contract. I think we have authority counsel who has had months of experience and the benefit of Mr. Bowden. I don't see the need to continue and enter into a new contract.
Michael, would you like to address that?
This was included in the budget, Chair, and it was an item that the board understood. I think Authority Counsel John Giffen indicated a need for Mr. Bowden's services for a period.
Any other comments by board members? Out to the public, any comments by members of the public? Back to the board, I would
I'll make a
entertain
motion.
a motion. Okay, Mayor Rubio makes a motion to
To approve the contract.
approve the contract, and a second from Vice Mayor Ian Oglesby. Any discussion? All in favor, signify by saying aye.
Aye.
Anybody opposed?
No.
Okay, we have two noes, Gil Morton and Frank O'Connell. Okay, thank you very much. Next, we have the long-awaited, the three board requested reports. We'll start off with the legal authority for consistency determination. Michael will provide an overview of this at this time. Michael?
Yes, Chair Edel and members of the board, these three items are all board requested reports that have go back to January of this year. In fact, the board members had wanted to have some verification and legal work done to understand what would happen in the board's deliberations with respect to adjustments, changes, or modifications that were recommended under the base reuse plan reassessment process, which was completed last December. And after that, during board workshops, they requested the legal authority for consistency determinations and some work on CEQA. In order to make that happen, the board authorized the execution of a contract with Alan Waltner, and Jonathan Garcia will introduce that in a few minutes. The board also, a couple of months ago, Supervisor Parker requested that Authority Counsel John Giffen provide with some legal opinions about language that was included in the board report about FORA's land use authority, and John Giffen has completed that and will make a report in a few moments. And then finally, the third is about prevailing wage requirements, and I'll do that in a few moments. The board requested something akin to a conference and training on this particular issue. We attempted to structure one, and that didn't come through, and so the board has asked that this be before the full board today so that it be on the record, and then we probably will do something similar to this with our members of the administrative committee in a few months.
Thank you, Michael. Jonathan, I believe you're going to introduce Alan Waltner.
So back at the the FORA board workshop in March, the board directed FORA staff to retain a land use and CEQA attorney to look retrospectively and prospectively at the Category 2 items related to consistency determinations and other board decisions. FORA hired Alan Waltner, which was approved by the FORA board at the April board meeting, and Alan has extensive experience with National Environmental Policy Act and California Environmental Quality Act issues. His work experience, career experience includes work with Oric, Harrington, and Sutcliffe, the US EPA as a supervising attorney for air pollution and toxics regulation. Also work with the UC system as attorney for permitting and environmental impact reporting, and also with the San Francisco office of Bingham McCutcheon as a partner in the land use group. And I'll let Alan do his presentation at this time.
Good afternoon, Chair, members of the board. I'm Alan Waltner. I'm a land use and environmental attorney based in San Francisco. But over the years, I've actually done quite a bit of work in this region, a lot of it with Rob Wellington, who many of you know, and for various local agencies here. Specifically, I assisted the City of Marina for over a decade as outside environmental and land use counsel, and, for example, read the Army's environmental impact statement on the transfer and habitat management plan. So I've been involved in these issues for quite a while. I started working with FORA in 2007 when it was anticipated that the reassessment would occur at that time because the triggers of the settlement agreement were about to be reached, but the recession took care of that. So in any event, today I've been asked to talk about the consistency process, and I think I'd like to start by thanking Scott Walsh of the Sierra Club for his kind words in the letter submitted yesterday about the 2 memos that I prepared on this subject. There's a lot that could be said. I'm mainly going to hit the highlights. I think if there are questions, feel free. If there are specific concerns, my understanding is that some questions had arisen as to the validity of some of the previous consistency determinations that were made in connection with general plans. Seaside was one example that I looked at specifically, and I'll address some of those issues. I think it is best to start by stepping back and looking at the structure that the Authority Act created here, where the base reuse plan is kind of like a general plan. It's described much like a general plan in the Authority Act. And you can't really have 2 general plans competing for the same area. And that's why the Authority Act set up a system for the base reuse plan to create a framework and a guiding framework for the base as a whole. And then individual jurisdictions come in, the jurisdictions that usually do land use regulation, the cities and counties and their planning departments come in with general plans and other actions that are reviewed for consistency by the FORA board. Now, there are a couple, the master resolution has a lot of detailed requirements about these, but there are 2 in particular that I think I want to highlight. The first is that in this translation from the base reuse plan to a general plan that's deemed consistent, the master resolution allows densities to be moved around. It explicitly does that. An example is Seaside. There were a list of 10 specific differences where changes were made, but the overall balance of land uses and densities remained the same. And that approach was expressly contemplated by the master resolution and was, in my opinion, was perfectly appropriate. And then the next major point to highlight is simply that once the general plan is determined consistent by the FORA board, the lead for most land use decisions moves to the local jurisdictions, and the benchmark for evaluating consistency of future actions for most purposes becomes not the base reuse plan, but instead the general plan and the uses in there. So in practical effect, one of the effects of a consistency determination is to essentially render functionally render that part of the base reuse plan basically obsolete or superseded by the local general plan. Now, there are some provisions, and there may be some interest or questions about this, when you get to the next stage, when you get to individual development entitlements, there's a list of 8 requirements for determining if projects are consistent. Now, that only happens if there's an appeal to the board, but those are very interesting in that the two key tests are whether the uses and the densities are the same as in the approved general plan, not the approved base reuse plan. So this basically answers the question of whether the base reuse plan has to be amended before general plans can be reviewed for consistency. The answer is no, because of the flexible standard for evaluating consistency and specifically the fact that densities and land uses can be moved around. Now, there's a list, when you get to the individual project, there's a list of 8 different requirements, and those are 2 of them. And some of the others relate more broadly to the base reuse plan itself, policies, infrastructure, financing related to the particular project. So FORA is not completely out of the picture once a general plan is determined consistent, but has this limited appeal jurisdiction and some limited handles or hooks on individual projects going forward. So that's basically my capsule summary. I don't know if there are any questions. I'd be happy to address them.
Yeah, thank you very much. Your reputation for legal analysis prior to us hiring you was outstanding, and what we see here is rock solid. Thank you for all your work.
Okay, thank you.
Any questions from board members? Seeing none, out to the public. Any questions by members of the public?
Levon Stone, Director of FORA and Environmental Justice Network. The problem with the general plan, and supposed to be the difference between the reuse plan, is that the reuse plan is the plan that came out of the communities that were involved when the bays closed, and we had to come up with a plan of how to reuse this base, how to get our communities back up and running economically, how to address the health problems, how to come together and support those communities and the residents and the people who were impacted by what happened here with this federal process that had nothing to do with the people and what happened as a result of it. So I don't really see a difference and why we should separate the two. According to the state of California, environmental justice is supposed to be implemented everywhere, especially in general plans. They have a whole document out there right now. And environmental justice is about the environment of the people. The environment of the people, and not just the environment that's concerning the trees and all that. There's supposed to be a balance. We don't have a balance here in Monterey County. We are still looking at how we need to do this thing, when all we have to do is look at the community, work with the community, look at the community like we're all people, and not some of us as the public, some of us as not sitting on the FORA board when we should be, and not participating in the decision-making process. And we keep saying the same thing. When is it going to happen?
Thank you, Ms. Stone. Michael, you want to respond to that? I'm sorry. Let's see if there's any other community input. Any other community comment with regard to Mr. Waltner's presentation?
Scott Waltz, who you mentioned, the Sierra Club. The Waltner memo seems to speak primarily to the alignment and latitude, but there are a number of qualifiers in there that reveal how the forest situation is unique. I would certainly appreciate Attorney Waltner speaking more to especially that phrase about issues of first impression, which seem to suggest unique legal matters as they bear on this. And I'm not a lawyer. I might have a misimpression of what that means, but if you could speak further to that, that would be appreciated.
Yeah, please. Thanks, Scott. I'm sorry? We're at public comment right now. Okay. And he's answering a question by public comment. You want to answer that just so we have some train of thought in the continuity of what we're talking about?
What Mr. Waltz was referring to is a comment that I made early on in the memo that the issues here are really unique because of this unique structure created with the base reuse plan and a specific provisions that haven't appeared in anywhere else, and so there hasn't been any case law specifically on a lot of these issues. What does it mean to be consistent? How much latitude is there? That sort of thing. And what that did in terms of my analysis is I had to go back to sort of basic rules of interpretation and statutory construction, look at the master resolution itself, try and make a prediction as to what a court would say. And in doing that, there were two very key pieces. One is that the base reuse plan and general plans are described very similarly in the Authority Act and in the Planning and Zoning law. So I concluded that a lot of the case law about consistency under the Planning and Zoning law could be applied by analogy to consistency determinations made by FORA. And that was a big part of the analysis. There aren't cases on FORA's consistency reviews because nobody's challenged them yet.
Right. Thank you, Mr. Walter. Any other member of the public wishing to ask any questions? Okay, public comment period's closed. Michael, do you want to address Ms. Stone's?
Right. My understanding of Ms. Stone's comment is tied to the fact that the base reuse plan is a community plan, and it appeared in her comments that she was distinguishing that from general plans maybe not being as much of a community plan. She also focused on environmental justice. There shouldn't be a difference between the BRP and general plans of the communities. I believe that the overall base reuse plan seeks to have a jobs housing balance. It seeks and encourages each community to offer jobs to local entities. That's something that's in the base reuse plan and in state law about FORA's authority. Environmental justice, in my opinion, should be applied to both with respect to the economic opportunities that are afforded here, as well as any opportunities related to the engineering or construction or other jobs that are here as well. And so I don't believe that I don't believe that the distinction that Levon pointed out is in fact any change. I don't think anything that Alan Waltner said today about land use and consistency determinations would change that either. I still believe that the base reuse plan encouraging environmental justice and community participation does not change, whether it's general plan or base reuse plan.
Thank you, Michael. Any other follow-up questions from board members? Yes, Ian.
I did have one, Chair, and I think it's pretty simple. I just want the consultant's determination, or could he explain to me, you said one exception would be actions by the member agencies may be reviewed by the board on its own initiatives and then may be appealed to the board. Right. Who can make that appeal to the board?
I believe Mr. Giffen might answer this, but I think any member of the public would be my reaction.
No, I got, and I think we talked about that before, but I just want to make sure I understood the exceptions. Okay.
Any other questions by members of the board? Yes, Tom?
Just one question, one comment. It probably was just an oversight, but Mr. Waltner's September 3rd memo was not included in the board packet here. I read it online, but didn't happen to bring a printed copy with me. So just in the future, I'd love to make sure we have those on the dais. I want to make sure I understood what you said in that memo on one issue. When it comes to specific projects, if I understand Chapter 8, I believe it is, of the Master Resolution, it indicates that this board must find inconsistent any specific project that doesn't meet all 8 of those criteria that you mentioned. Is that true? And a failure on a single criterion?
That's the way the Master Resolution is framed. That's correct.
So failure on one of those means the board is obligated to say it's not consistent.
That's what the Master Resolution says. I think there's a question that I really didn't address, whether the Master Resolution is consistent with the Authority Act in all these respects and everything that was included in that section. But I think at this point it's still the operative governing regulation for these determinations. And I think it's important in looking at each of those 8 items to read them carefully, because all of them basically have a certain degree of flexibility and room for interpretation. And an application, and a lot of them only require, for example, the provision or providing for funding for infrastructure to support the particular project, that sort of thing, not doing everything that needs to be done for the base as a whole. So I think it's important to read the the limitations on each of those requirements, and that's what the board staff has done, as I've understood it in their staff reports. They've gone through and read these pretty carefully and applied them pretty accurately.
So if there is any remaining uncertainty in this regard, you would, of course, love to have someone sue FORA so we could get it resolved in the courts.
I would not like to see anyone
joking.
sue FORA.
Thank you.
Okay, any other questions from board members? Okay, seeing none, I'd entertain a motion to receive the report. Okay, Mayor Rubio, and second by Mayor Pro Tem Frank O'Connell. Any discussion on the motion? Okay, all in favor signify by saying aye. Aye. Anybody opposed? Motion carries. Thank you very much. Okay, the next board request for report is the FORA Jurisdiction Land Use Authority. John Giffen will present that.
Thank you, Mr. Chair, members of the board. At the July 12th meeting, after Stan Cook did a presentation on the ESCA, Supervisor Parker asked about some of the language in his report and asked me to prepare a memorandum concerning what state law says about FORA's ability to regulate land use. The memorandum that we prepared is generally is pretty broad and is intended to be kind of an overview, in general, FORA's role in making land use decisions is really divided into three categories. The first is that FORA can make consistency determinations authorized by the Authority Act. That's really what FORA does. The second way it can influence land use decisions is through contract. There are controls, but those are primarily through implementation agreements. And third, it can exert power over property through direct ownership. So the three ways: make BRP consistency determinations authorized by the Act, have contracts exert control over the property, or through direct ownership. Next slide, please. What FORA does is make BRP consistency determinations is one of the biggest. That's the land use function. FORA's powers and duties prevail over any local entity, including city or county. The board creates the base reuse plan, and the local jurisdictions implement it through their own general plans. And obviously there's a little overlap here from what Mr. Waltner just presented. This is intended to be a little bit more broad and general. His was a little more specific. But through the local jurisdictions' general plans and zoning ordinances and the permit approval process, that is how the FORA board creates first the FORA board creates the BRP, and then the local jurisdictions govern through their general plans. The next point is the FORA board enforces the BRP by declaring the general plans, ordinances, and other implementing actions to be consistent or inconsistent with the BRP. Those are through the government code as cited there. And the Forward Order Reuse Act then delegates all the development review authority to the county or city over any development proposed within the area to which the general plan applies. There's one exception, and that is that the actions of the member agency may be reviewed by the board on its own initiative or may be appealed to the board. And I think that answers the councilman's question concerning who has the right to make that appeal. Next slide, please. The second way that FORA makes land use decisions or influences land use authority is through the ability to contract. It can contract with the United States to receive title to property, to enter into agreements. The implementation agreements are really the primary, most important contractual expression of how FORA can regulate the land use. Next slide, please. And finally, through ownership, FORA is authorized to accept title to land from the Army. There is no specific law that allows FORA to retain property for the express purpose of influencing land decisions, but FORA can retain title if the board determines that it's necessary or convenient to carrying out FORA's responsibilities pursuant to law, or the board determines that retention will not cause financial hardship to the city or county with jurisdiction over the property. So that's again, this is very broad, and I have talked to the supervisor, or Christy Markey, and I believe I addressed the question that was asked. In conclusion, the last slide, please. FORA can influence land use decisions, can influence land use by making consistency determinations that ensure compliance with the BRP. FORA may influence land use by contract, and finally, by ownership of land. And that concludes my presentation.
Thank you very much, John. Any questions by members of the board? Yes. Gail.
Just an arbitrary question.
Yes.
My question is implementation agreements that are entered. I know there's one with the City of Marina. Are those, what is the procedure if someone wished to amend those? Is it feasible the city might initiate an amendment? FORA board might try to initiate an amendment? I just want to know.
That's a FORA board province. Yes.
Thank you.
Yes.
Any other questions by members of the board? Saying none out to the public. Any questions by members of the public? Can we have the lights on? Either that or my eyes are getting very dim right now. And Frank will be taking over very shortly. There we go. Thank you.
Again, Levon Stone, Director of FORA and Environmental Justice. It sounded as though I heard the comment that the FORA board created the reuse plan, and that is definitely not true. The community reuse plan was in place before the FORA board was even formed, because that was when the people in the community, especially the impacted communities, got together after they found out how many people were losing their jobs and their housing and their families. They got together to create a plan, and the FORA board was formed to implement that plan after the Army cleaned up the property. Then it would be turned over to the FORA board to be implemented with the community, with the people in the community, with those folks that should be at the table, not to discount them and create this elite group that would make all of the decisions without our participation in the decision-making process. And I'm saying again, that's what's been happening. Somebody told me, oh, the FORA board's not listening to you. Well, that's too bad. That's why we're in the state that we're in right now and are continuing in the state that we're in right now, because the people, the local folks in the community should have been the first ones addressed in this whole process. Instead, we've gone backwards. We're bringing in all these folks. We're bringing in all kinds of ideas. We have completely put the people who were hurt the most on the back burner and not addressing their needs. Not even the networks, not even the community groups that have been working on this process. And it just doesn't make any sense. So if we're going to keep on talking about it, we'll keep talking about it, because it has not been addressed. The local community impacted, affected, has not been addressed in this process.
Thank you, ma'am. Any other members of the public wishing to address the board on this issue? Seeing none, public comment period's closed. Back to the board. Any follow-up questions or a motion, please? To receive the report?
Motion to receive the report.
Mayor Rubio, and second with Mayor Pro Tem, who? Oh, Mayor Gunter. Thank you. Any discussion on the motion? All in favor, signify by saying aye. Aye. Anybody opposed? Motion carries unanimously. Thank you very much. Next, we have a presentation, Prevailing Wage Requirements and Enforcement on Fort Ord. Michael will present. Michael, take it away.
This too, Chair, will be a PowerPoint presentation. I hope you can hear me. Is this microphone working well enough?
Yes.
Good. Let's see if we can get. Chair Edel and members of the board, I mentioned earlier that the prevailing wage enforcement and application question had come up several times in the course of the last few years. Over the course of FORA's history, prevailing wage has been a discussion that has included everything from whether prevailing wage applies, where prevailing wage applies, how prevailing wage applies, and often we've had some disagreements about prevailing wage and its application at Fort Ord. There have been lawsuits that have stipulated how it would be applied on specific projects on Fort Ord. There are simple questions that sometimes can be complicated more by the questions that are posed than by the actual fact. And I'm hoping today, in going through this brief presentation, it'll be a positive step for the board, the jurisdictions, and the region with respect to prevailing wage at the former Fort Ord. On this first slide, which there we go. Just a little definition about prevailing wage. In particular, this definition that we have on the board is really about the law. That is the premise that government really is the major public client in this local economy and should use its buying power under state contract law to provide adequate wages. You heard under the past two presentations about FORA being established in state law. You also know that the individual jurisdictions underlying Fort Ord, such as California State University, Monterey Bay, the University of California, Monterey Peninsula College, are state agencies that have requirements about prevailing wage, but also the individual jurisdictions have adopted prevailing wage rules and laws as it pertains in their jurisdiction. And in past years, prevailing wage has applied as it pertains to the use of redevelopment funds when redevelopment funds were available in certain circumstances. So there were a number of reasons why prevailing wage applied at Fort Ord, but it particularly has to do with the hourly wage, including benefits and overtime paid to, and this appears to be an accurate statement, the largest group of laborers, mechanics, and other tradesmen within a particular region. The next slide points out a couple of things about prevailing wage in California. We in former Fort Ord describe the public works that we have prevailing wage on as construction, alteration, demolition, or repair work done under contract and paid for in whole or in part out of public funds. So that's straight out of Labor Code. In Fort Ord, we define that a little more because we talk about where it specifically applies. We often get the question of whether prevailing wage applies to a single-family house as someone trying to define for themselves how that works, and I'll talk about that as we get into the rest of my presentation. This is the general prevailing wage of hourly wages is determined by the California Department of Industrial Relations is important. It's the general prevailing rate. That's what's applied at Fort Ord. We know that there are two separate regions. That prevailing wage rate is defined for different regions. It's not always defined the same way for each individual labor section, but at Fort Ord we've always used these as the predominant governing codes. In the terms of history at Fort Ord, the prevailing wage application at Fort Ord goes all the way back to discussions that occurred when the community plan that Levon Stone talked about earlier was under discussion in 1992. It goes that far back, and especially during the discussions when state law was being created to create Fort Ord. There was a discussion about including prevailing wage as part of the Authority Act. That was part of the intent. If you go back and look at the legislative history, there are a number of references to prevailing wage in the legislative history. But in fact, FORA's first procurement code was adopted in 1995, and that's the very first time that there was, in effect, a provision that described the application of prevailing wage at Fort Ord. There are a number of other important dates that are there on the board that talk about this. As I mentioned earlier, there were a couple of cases where there were lawsuits that specifically had an outcome that described how prevailing wage is applied in certain circumstances. There was a Master Resolution Amendment back in 1997 that did a clarification of what's known as first-generation construction. In essence, it's construction up until you get an occupancy permit. And many folks ask that question, what happens if there are substantial construction activities that occur after an occupancy permit? Well, at Fort Ord, it's defined. It's specifically post-occupancy permit is not governed by prevailing wage. Now, there are some circumstances where they would be, but by and large, that's the rule. Next page. The master resolution requirements, as I mentioned before, shall be paid to workers for first-generation construction on parcels subject to the base reuse plan. In essence, all of the former Fort Ord is subject to the base reuse plan. However, there are selected areas that are excluded, such as the Bureau of Land Management's property, because the United States is, in fact, sovereign. I use that term in this case because it does mean sovereign. And because of that, federal law and Davis-Bacon wages are paid when the Bureau of Land Management does its construction. There also are some circumstances where a federal grant requires that you use a certain provision. So that's slightly different. There's also California State University Monterey Bay, which under state law has to apply a certain prevailing wage which state law governs. And so there are certain circumstances where it's slightly different. So the rest of that is pretty clear, I think. Member agencies provide the notice of this policy in all contracts and deeds. City of Marina, for example, in every one of their development agreements and every one of their applications has always provided the provision that the prevailing wage policy applies in the contracts and on their work on the former Fort Ord. Similarly for the City of Seaside and for the County of Monterey. Most of the time, FORA is responsible for the base-wide activities and their compliance with prevailing wage, but the individual jurisdictions are required to deal with enforcement in their contracts. Next slide, please. The last board meeting, there was a lot of question about exceptions. These are the exceptions that are specifically listed. This is a summary. This is not the precise language, but it's close. So it's the FORA or member jurisdiction construction workforce. So in the event, City of Delray Oaks has a small construction workforce working on a small road project, it would not necessarily apply if it was the jurisdiction's workforce versus under a contract. Similarly, for developers that have full-time employees doing construction work, not where you would have your employees serve as a shill to prevent having to form a contract where for other requirements would require a contract, but where that is full-time employee construction work. I mentioned before the post-occupancy construction work. That's pretty clear in the master resolution. There's a comment here about affordable housing. That comment has also come up 4 times in the last 3 years at FORA board meetings. There are very specific circumstances where affordable housing, as exempted under state California law, would have to follow their provisions for how that would work. Sometimes folks assume that just because it's affordable housing, it would be exempt, but unless it's a California law and a designation by the Housing and Community Development Department, it is not exempted. That's typically the correct interpretation. And then there is a comment in our that allows facilities constructed for charitable purposes and are owned by a nonprofit organization to be exempted. We don't have any of those circumstances as yet. In one case, we did. That was Goodwill Industries on the former Fort Ord. In that particular case, they did have certain construction that would have qualified for this, but they paid prevailing wage anyway. Next item. So how is it applied? Pretty standard. All bid documents contain information regarding prevailing wage. The prevailing wage rates are easy to find, so they're always published. The bidders are always also informed about the rate, and it applies not just to contractors but to subcontractors if they have more than 5% of a total contract. And then, of course, prevailing wage rates apply to the signed contracted project. They don't necessarily extend to workers who are ancillary to the construction. So, for example, if a truck driver delivers materials under a contract, that may not apply that way. Next is respect to enforcement. FORA typically is the enforcement agency. The provisions in Chapter 2 of the Master Resolution provide methods for enforcement. FORA also has the consistency determination process. If people are not complying with prevailing wage, we can withhold consistency determinations. That legal opinion has already been provided to the board at least twice that I'm aware of. We typically take the enforcement measures that are required when a correction is required. We've had a few circumstances where we've made those kinds of reports. In a couple of cases, the contractor has worked directly with FORA and paid for FORA staff. In fact, Stan Cook, was part of his work was to do the prevailing wage monitoring and compliance on 2 contracts that I'm aware of. Most of the time, however, it's the jurisdiction's requirement to do the certified payrolls and to do the compliance. And the next page, by the way. Specifically, if you want the detail about this, there's the California Labor Code sections that you can review and determine for yourself the detail. In the past, California Health and Safety Code applied. In certain circumstances, sections of California Health and Safety Code still apply. There might be a jurisdictional requirement. City of Seaside has a very specific prevailing wage requirement. Also, our prevailing wage policy and the master resolution for enforcement. The last item talks about the frequently asked questions that we get. We have compiled those frequently asked questions. I mentioned a few of them today. We've provided answers in each case so that you can go right to the FORA website and find those FAQs and determine for yourself about how prevailing wage applies. And finally, Chair Edelin, there are 1 or 2 members of the FORA board who are probably much more qualified than I am to give this presentation, and there are also some folks in the audience who I know will have a couple of comments as well, because they're equally qualified at least as a couple of members of the board on prevailing wage. And I offer the opportunity for questions and or for any further exploration of prevailing wage, Chair.
Thank you, Michael. Excellent presentation. Questions by board members? Yes, Bill.
Thank you. There was something in there about primary construction and how the deeds would record the requirement for prevailing wage. And I wasn't quite sure how the deed played in, because it would seem to me that carries with the property forever. How does that work? I understood the contract part.
Well, a couple of ways. Well, first of all, the implementation agreement that the Fort Ord Reuse Authority has with each and every one of the jurisdictions has a requirement that that implementation agreement be recorded with each parcel. In it, it specifically says that all of the conditions within the master resolution must be complied with by the jurisdictions. And so, in that sense, every deed carries with it a restriction that specifically lists prevailing wage.
Thank you.
Other questions by board members? Seeing none. Out to the public. Any questions by members of the public?
Ron Cheshire. No questions, Mr. Chair. Thank you very much. FORA is unique. I think that all government jurisdictions are well aware of the public works requirements and prevailing wages on your agency projects. What's unique about FORA is that private work also has a requirement for prevailing wages, except for the exceptions. And if you want to know about the exceptions on housing, you may talk to Supervisor Salinas. I think he was in the assembly at the time when they made some exemptions for the affordable housing components. So that's what's unique about FORA, is that the private work is subject to prevailing wage. And it's something that's steeped in a long history that most of you don't know. It's something that the community wanted. Today, I could have brought you documents that I dusted off the other day as I went through, showing you the formation of the Tri-County Building Industry Alliance. It was a group of individuals, architects, engineers, labor representatives, the Builders Exchange, people within the construction industry that were concerned about what was going to take place out at Fort Ord. We band together, and for years we discussed this. We did get together. We did make comments under the community plan. We lobbied FORA before FORA was even FORA, when it was Forge. And in your procurement code, the first ordinance that FORA ever passed, you included prevailing wages pursuant to agreements with developers, which eventually got changed and is now your current prevailing wage requirement on public and private work. It's something the community wanted to level the playing field. They wanted to be sure that the businesses were working on a level playing field to get the work, and that the workers would benefit from a standard wage so everyone could get a piece of the pie of what the promise was for FORA.
30 seconds.
We've had some challenges, and we hope we don't have to go through a lot more of them. But if you ever require any information, I'm more than willing and able, ready to talk to you in regards to it. You might think I'm biased, but I will present to you any information. I will document
10 seconds.
what's there, and look forward to working with you and doing what's right for workers and what was the promise of several years ago. So thank you very much.
Thank you, sir. Any other member of the public wishing to address the board on this issue?
Yes, Levon Stone again. I'm very glad to see what has happened within the construction industry concerning prevailing wages. It certainly took long enough, and I hope that it's going to continue. I just wanted to add one more thing. We're working very hard for a local hiring ordinance, which we feel should also take place here in this county, so that the local people can get jobs and won't have to keep on competing with a whole lot of outside labor without them being in the front of the line. So I'm very glad to hear that that has gone through, and I hope that very soon that this ordinance will pass.
Thank you, ma'am. Any other public comment on this item? Seeing none, public comment period's closed. Back to the board. Any last minute discussion? Yes, Mayor Rubio.
Yeah, I just want to add some comments to Mr. Cheshire's comments. The whole idea was to protect local workers and protect the local economy. It's not an issue of what type of construction company you are, but no matter where you're from, you're going to participate in this economy. If you're from a low-wage earning area, you're not going to bring your workforce here and undermine the ability of local people to participate and be viable in their own economy. This does support our local workers, it supports our local businesses, it supports our local jurisdictions, because those folks that stay here and earn the money it takes to live here will spend money in those jurisdictions and create the economic base that is necessary to revitalize this base. So I know there's been a lot of discussion about it, but it really is to protect our local economy and to help revitalize this economy here.
Thank you, Ralph. Any other discussion by board's members? I'd entertain a report to a motion to receive the report, please. Okay. Okay, Mayor Rubio and Mayor Pro Tem Ian Oglesby is the second. Any discussion on the motion? All in favor signify by saying aye. Anybody opposed? Motion carries. Thank you very much, unanimously. Okay, next we have new business. Stan Cook will present a resolution authorizing application and acceptance of a building removal business plan grant. Stan, take it away.
Thank you. While we're queuing up the PowerPoint, I'm going to go through a couple of highlights in the board report. FORA has actively been removing, reusing, and recycling former four-door building stock since 1996. For more information on that, you can look at our annual report that we just published. It's on pages 22 and 24. CSUMB has actively been reusing, removing, and recycling buildings for many years. It says 2001 here. It's actually, they started reusing buildings back in 1996. Currently, there's 65 concrete buildings that are in the city of Seaside and on CSUMB's property. In the past, FORA and CSUMB's building removal research and removal activities have focused on what were known as the World War II wood buildings that are here. We have quite a bit of information on those buildings. We have very little information on what those 65 concrete buildings include. So if we could go to the first picture, I'd like to go through a little background. You have the little... Okay. If you look at this, FORA has been working on, we did a pilot deconstruction project, started in 1996, it went to 2002. We looked specifically at asbestos in 1997 and how that affected building removal. We looked at the FORA hierarchy of reuse, which is reduce, reuse, recycle, which is let's try and reuse our buildings first, then try and reuse the materials, and then try and recycle the material. We did that in 1998. We also looked at contractor qualifications to find the right people to do the work we need to do, building removal here on Fort Ord, and we looked at that specifically in 98. We looked at the impact of lead-based paint for years on Fort Ord and how that affected our ability to reduce, reuse, and recycle. Then we looked at characterizing our lead-based paint, our building materials. These were all wooden buildings as you look all the way through here that we looked at, until we get down to this point right here, which is 2011. FORA removed a building in Seaside, 4470. At the same time, CSUMB removed one of their what are known as the hammerhead buildings, and I'll show you those in a minute. Back in 2011, there's very little information on these concrete structures. Originally, when the base closed, they were looked at as a potential reuse, ability to reuse these buildings. As they've aged over time, that ability to reuse them has gone down further and further. CSUMB has made attempts at that, but these buildings are very hard to work with. They're concrete. You cannot, they have limitations between the floor and ceiling. It's one of the biggest problems, in ceiling height. So CSUMB, you can see they have quite a history of building removal here. FORA's got quite a history of building removal. Back 2 years ago, we started looking at a grant application after the legislative committee went back to D.C. and talked to Office of Economic Adjustment. Next slide, please. Oh, I've got the thing. Let's see if I can do this. There it is. Great. Okay. If you look at the area we're talking about, this is Giggling Road. This is the DOD, the old hospital, the DOD building. This is what's known as Surplus 2 in Seaside. Some of these buildings are currently have been reused by, here's MPC's campus, a portion of it right here. This is the Monterey College of Law. This is Colonel Durham Road. But in here, there's what they call the rolling pins. If you look at it, the silhouette is, or the the plan view of it kind of makes a rolling pin figure. These are the hammerheads because they look a little bit like a hammer from their footprint. These hammerhead buildings go through CSUMB into Seaside. So these are very large structures. They look like this. This would be the hammerhead portion of it. This is the handle on the hammerhead. They're severely dilapidated at this time. They've been ransacked for the salvageable materials that are in there over time. We have a housing that is currently occupied by the military here. We have the National Guard here. We have CSUMB's center of their campus, and we have students that are actively around these. So we want to look at how to remove these buildings as quickly and as efficiently and as cost effectively as possible. To do that, we have asked for a grant to create a business plan. We go into this for the Office of Economic Adjustment, and they were decided to partner with the Economic Development Administration. This would be a joint FORA CSUMB grant application with FORA as the lead. That's required by Office of Economic Adjustment. We would develop a building removal plan for 65 buildings, 26 in Seaside, 39 in CSUMB. These are specifically those concrete structures, and they're complicated by asbestos and hazardous materials for the removal of those buildings. So this is, once again, it's a request to authorize us to apply for the grant and to accept it up to about, we're looking at a number around $250,000 if we're successful. Thank you.
Thank you very much. Excellent presentation. Any questions by members of the board? Yes, Bill.
I guess the part that wasn't clear to me is what is going to be in the business plan that makes it easier to get these buildings removed. To what extent does this substitute for having the money to just do the job?
Let me talk about it in two different areas. This is to try and harness market forces that are out there to see if there's ways to reduce cost or if there's ways to use some of their access to the property, maybe the materials that are in the building as crushed rock or something like that, to maybe offset some of their costs. Maybe they could use the area over time, turning over with maybe a stipulation of how many square feet of building have to be removed to pay for a rent on the property. The idea is for us to go out and work with the community that removes buildings and to help them develop a business plan. What gives value in that property to them for a while, for use of it for a while, to give them an incentive to take down those buildings at, for no cost or below cost. We don't know what that is exactly. I do know that in my 18 years of working on building removal here, there are very few organizations that will pay for something if they can't put a plaque on it. When you take a building down, you have nothing to hang a plaque on. So we've tried and tried and tried for 18 years to get someone to just give us money to take buildings down. It's not out there.
I'd just like to add this $250,000 we expect to have come in here is a direct as a result of the FORA legislative mission that was sent to Washington here earlier this year. And not only the legislative mission, but we met with, our team met with Patrick O'Brien, and it's not only the team, but also our executive officer, Michael Hulamar, the relationship he's established with Patrick and other individuals in Washington, D.C., is why we have this money. There's no doubt if that legislative mission had not gone to Washington, if Michael didn't have the type of relationship that he has with the key players there in Washington, we would not have this money coming down, and we would not have a lot of the money we've gotten up to this point. So I just want to say that from my own observations of being on that trip. Any other questions by members of the board? Yes, Tom?
So just a quick question. These buildings are hard to take down, particularly hammerheads, because they're more or less bulletproof, right? They're pretty sturdily built, shall we say?
They're pretty sturdily built, yes. I would have to tell you that.
So do we have a study that absolutely clearly says it's going to be way more expensive to reuse any of these rather than tear them down and build new?
See, do you want to take that, Michael?
No,
Go ahead.
Yeah, Eduardo Ochoa may want to jump right across the table to enter into this discussion, but I did speak at some length with the facilities leadership at CSUMB years ago. The campus reused several of the Hammerhead buildings, and after the work was completed, because of the lack of depth for interstitial space, the lack of other architectural features, it actually costs more than a new structure to reuse the building. Eduardo may have more detail, but that was the report that we got back from CSUMB for these specific Hammerhead buildings.
Specifically, we did a full remodel on a building for student affairs, and that was our experience. By the time we were done, it cost more than it would have cost to build a building from scratch.
To tear down and build from scratch, or just to build a new one from scratch?
I think it includes the tear down as well. Yeah, it's tearing down one of those buildings is about $1 million each, including the hazmat handling. So.
Okay, any other questions by board members? Yes. Oh, I'm sorry. Ian?
Yeah, I don't know, a couple comments, not really. I think this is the opportunity for the board to really see what's going on here again. You know, we're debating about whether we should, I don't know what FORA is doing, asking. FORA doesn't own any of these buildings. So for us to be trying to act like, well, maybe they should be reused, then unless you're going to buy them, then they should be torn down, or whatever the reuse authority in that jurisdiction wants to do with them. We have 26. And my understanding is, I think Dr. Ochoa just put on the record, roughly cost $1 million to tear them down. We have 26 of them. So FORA's responsibility is to help us tear them down. But you guys are supposed to get the money from redeveloping, economic development, using the land that we were given to develop. But I know we're being stopped from doing that. So when you say this money comes from you guys doing your a trip to Washington, D.C., hat in hand again, you're talking to the same people that gave you the land to use for economic development to tear down these buildings. And then I hear Stan say, well, there's really nobody going to tear them down for free anymore. Who's going to do that? So I just wish we would stop going in a circle and just realize we have the land to use to develop and get the money to tear these things down. FORA is going to go away, as you know better than me, Chair, in 6 years. And by then, Seaside probably still have 26 hammerheads up there. But I'm going to continue to put pressure on the board to use their money to do their share. And out of the 26 that we have, 4 is only on the hook for $4 million worth of teardown. So either way, Seaside is left with the remainder. And so my question is to 4 is, are we going to concentrate on tearing them down, or are we just going to go from year to year and say, well, we don't have the money, we're going to go hand in hand to get the money. At the same time, we're not going to do economic development, because I don't think we should spend the money to keep on going around without, we need to spend it if we have it. And I know we don't have it. But to keep on talking about reusing these buildings, we can't reuse these buildings. No one, who wants to be in these buildings with the asbestos, with the size limitations, and being built in when? During the Korean War. Who wants those buildings? Nobody wants those buildings. So we just need to do our job, which is tear them down as we get the money. So I appreciate you guys doing the trip up there to get the grant, and hopefully this grant will generate some type of activity that tears them down, and we'll go from there. But we just need to go ahead and take action,
right,
and quit spinning our wheels. So thank the Chair.
Oh, thank you, and we'll try our best. Eloquently stated. Any other comments by board members? Okay, out to the public. Any comments by member of the public?
Ron Cheshire with the Monterey Santa Cruz Building Construction Trades Council. I would tend to agree with Councilman Oglesby, is that economic development would be the way, but if you were to go ahead and pass this, we would like the opportunity to work with FORA. There are new things being developed and figured out all the time, and we live in our own little world here. I could contact the Building Construction Trades Department back in Washington, D.C., and therefore access whether this is being done anywhere basically within the world, and whether it's being done economically, feasibly, economically. So anyway, I will take this opportunity to sit up here and say that we told Hank Hendrickson years ago that he was crazy, but and the universities learned. But those buildings aren't built as tough as you think they are. They're not built to California standards, thank God. So if they were, they would be a lot harder to tear down than whatever is. But remember is that concrete achieves 90% of its strength within 7 days, 95% of its strength within 28 days, and then the rest of it just comes along in the next 100 years. The Korean War, well, it's been a long time, so those things, the concrete's pretty hard, but it's pretty brittle also. They'll come down. So again, we would like the opportunity to go ahead and work with FORA. It's not a commitment on FORA's part. I'm just offering it if you were to go ahead and pass this at this time. Thank you.
Thank you, sir. Any other member of the public? Okay.
Scott Walton, I have a different hat on. I'm speaking primarily as a member of the CSUMB community. I've walked around that property, looked at those buildings. I think that the surplus 2
Yes.
deserves all the attention that it can get. I think it's a wonderful economic opportunity, especially if you stand up there and you get the view not only over our campus of CSUMB, but into the Salinas Valley. It's lovely. And you have some terrific neighbors that were mentioned, like the Monterey College of Law. There's a lot of public attention to the Fort lands. I don't see a lot of attention necessarily coming to surplus 2, but I think it's a rich opportunity, even though it's a very pernicious problem because of the density of blight. But I would encourage the board to do everything that they can to support dealing with that blight and moving that forward into a property that brings together the communities of Seaside and CSUMB.
Thank you, sir. Next, public comment.
Levon Stone, Photo and Environmental Justice Network. Our concerns, there was at one time a deconstruction project where you had to apply this adhesive stuff on the building. We had one. Before you painted it so that the lead-based paint won't fall into the soil. And the premise was that friable asbestos is very dangerous when you take the construction down and it gets into the air. That's when it's the most dangerous. Our concern is whatever needs to take place, because it is very ugly and it's terrible, because how will the public be protected from the stuff that gets into the air? Not too long ago, we witnessed a building coming down where the detour was, and the stuff that was in the air, you couldn't even tell the difference from smoke and whatever it was. We have to work together here, okay? We got people working on the deconstruction, tearing them down. We got people working on, we need to look at the health impacts. And the thing about it, too, is a lot of the veterans would go and stay in some of those buildings because they wouldn't have anywhere else to stay, and then they would get arrested. They wrote a big sign on one of the buildings that said, how come some of these buildings can't be used and revitalized so that people can have a room to sleep in or something? Some of these buildings can be used, can be reused. I'm not sure about the hammerheads or whatever you call them, but I know that some of them could be. So it sounds like it's a situation where the community can work together to come up with a solution for this process. And, of course, the first thing would be funds.
Thank you, ma'am. Next public speaker.
Good afternoon, Mr. Chair, representatives, staff. My name is Carlos Ramos. I'm a Seaside volunteer, as well as a Monterey Peninsula volunteer. Let's just say Monterey County volunteer. I want to thank the staff for the presentation on the grant application, and specifically the question that Representative Moore made regarding the cost of tearing down buildings, and the history that was brought forward by both Mayor Pro Tem Oglesby and President Ochoa in terms of trying to use or reuse some of these buildings, and the cost factor, let alone the health factors that kick in trying to deal with the key word that has been used in our community, local and throughout this Monterey County, which is blight. Our communities have been held hostage because of that word. Because unless we develop and meet the third leg of economic development along with education and the environment, we cannot afford to knock down these buildings. I very much appreciate the effort of our Chief Officer Hulamard. God bless you. And thank you for having those relationships, not only locally here, statewide, but federally, to be able to move things forward. But the answer is not just in this grant. It's shaking off that hostage, if you will, scenario of believing and buying into that blight has to be knocked down and built upon before other space. You notice I'm saying other space. Other space. Because that space was and is for the people of Seaside, the Monterey Peninsula, and Monterey County, and the region. It was already a promise. And that promise has to be kept. So we applaud the grant application. Thank you for your report. Very well presented. But the big issue is that code word blight. And let's build on blight first before the other space. No. Let's meet the promise of not only dealing with education, which we've done a great job with, and the environment,
20
which we
seconds.
have done a tremendous job with. 70%, 70 environment. Let's work on that economic
10
component,
seconds.
please. Thank you very much.
Thank you, sir. Next speaker.
Tommy Assini, former FORA board member and a former student at Cal State Teach for a couple of semesters. And if you want to know what the cost of these buildings are, I don't know if they told you what Building 46 cost. Over $6 million to rehabilitate, yet to just make it usable for not the administrative issue that you had, they ran about $4 million. Some of them have those nice big 4x4 pieces of steel that run all the way through them. And a couple of years ago, some members of the Fort Ord Alumni Association were looking at the hammerheads. To take one hammerhead down, $2.5 million. In response to something Miss Levon Stone had to say, there were 500 homes taken down in the former Fort Ord area by Carpenter Road, Bakewell. Before anything was ever done, any asbestos materials removed, they would throw a bubble over the hazmat people were prepared for any possible fiberglass that may have. So a bubble was thrown over every building before and it was taken apart. You want to see what it costs to? There were 20 buildings turned over to the Veterans Transition Center. There was a lot of materials in there. The people that went in there to clean it up. It costs $125,000 to $200,000 per dwelling unit to rehabilitate those. So rehabilitating in some places depends on the type of what you're doing. The houses at the Veterans Transition Center were government houses, and they're turning them back into government houses, and the veterans are using them. But all of the hazardous materials were removed by trained hazmat teams. I know what it costs for a couple of your buildings over there that you didn't get from the Tandem or Antella and those people. So it is expensive to tear a building down.
Thank you, sir. Any other public comment? Going once? Okay, seeing none, back to the board. Any final discussion with regard to this item? Yes, Mayor Ruby.
Thank you, Mr. Chair. The barracks out there, the old hammerheads, my father worked on those, putting those together. He poured the concrete. I mean, that's a long time ago. And I worked on the tilt-ups at CSUMB is in-house now. So those things were done correctly. So they're built substantially. And whether they're old and starting to crumble, they're still going to be a burden to all of us. The grant will provide an avenue for us to look at the economies of scale in taking those down. If you take them down one at a time, it's going to cost a lot more. If you take them down in group, in mass, you get the economies of scale. You can get an operation in there that can do the deconstruction, do the crumbling, separate the steel out as a big operation and reduce the cost. You could probably cut it in half maybe. But that needs to be identified. I was listening to a contractor today that was talking about flexible concrete. So there are new ideas out there, and there are new systems and abilities to do this. And the reason that we have the ability for this grant is, yes, we went back to Washington and talked to Mr. O'Brien in the Office of Economic Adjustment. But it's not just those relationships. It's the proven fact that the money invested here by that Office of Economic Adjustment has borne fruit. We have an incredible success record with that office and the other offices in Washington, D.C. of using that money wisely and getting the job done. And that's why they're willing to work with us, and they recognize us when we walk in the door. So to all the former directors of FORA and the present directors of FORA, thank you for that ability to get things done, because that is the crux of the matter, getting things done. And people are willing to invest in this community so long as we show the resolve and the ability to get things done. Thank you.
Hear, hear. Good comments, Ralph. Any other comments? Okay, I'd entertain a motion to adopt the resolution authorizing application acceptance of a building removal business plan grant. Do I have a motion? Who was it? Who made the motion? Okay, President Ochoa made the okay, and Mayor Rubio. Okay, Debbie, did you have a comment, a discussion on the motion?
I'm sorry, I just wanted to clarify. The buildings on it?
Yes.
Including our property?
Right.
Yes.
That's correct, right?
No, it's not. It's only in
Oh, I'm sorry.
Seaside Surplus 2 and CSUMB property as, let me.
Yeah, go ahead.
See this area up here? This is 6th, that's 7th, that's Giggling, and that's Colonel Durham Boulevard. That's the DOD hospital there, and there's the National Guard. So it's, the General Jim Moore is right there. So it's this area in Seaside and this area in CSUMB.
Through the chair, I just want to make it clear. What we have developed over the years is a rather firm understanding of the work that you have to do to remove buildings that are wood frame buildings, World War II wood style buildings. What we're missing in our repertoire is an understanding of the options we have for hammerhead and rolling pin buildings. So once we fill out the gaps, we already know about the specific cost for smaller sized concrete buildings because we've taken them down, and we know about wood frame buildings. This helps us understanding about the one gap we have in our knowledge base. So therefore, in that regard, all of that knowledge base belongs to everyone here. So it is base-wide in its effort.
Thank you for the clarification. That's helpful.
Thank you for the question. Okay, we have any other questions on, we have a motion and a second. Yes, Ian?
I'm just going to take 10 seconds. I may be impartial to this. I'm going to vote affirmative. I think I used to live in that building right there. I used to live in one of them, definitely that one. My 4 years on Fort Ord, I used to live in the Hammerhead, so I'm a little impartial to tearing them down.
Yeah, we saw it on the wall. It said Ian was here, scrawled on the wall. So that wasn't you, I'm sure. Okay. Any other discussion? We have, yes. Yeah. He's marking his territory. Yeah, okay.
He wants to put a plaque there.
Yeah. Yeah, a motion by President Ochoa, second by Mayor Rubio. Okay, all in favor, signify by saying aye.
Aye.
Anybody opposed? Motion carries unanimously. Thank you very much.
Thank you.
Okay, as we move on. Okay, as is our custom, if we don't have a unanimous vote the first time around on an issue, we always carry it over to the next meeting, which is normally 30 days later. We've already had public discussion. We've already had board discussion on a vote with regard to adopting the fiscal year 2013-14 Forward Reuse Authority Capital Improvement Program as presented and voted on at the August FORA board meeting. So all we have right now basically is we need a second vote on this issue. So basically, all in favor, signify by saying aye.
Aye.
Anybody opposed?
No.
Okay, we have 2 noes, Councilmember Morton and Mayor Pro Tem O'Connell. So the motion carries, and we move on from there. Thank you very much. Next. Okay, we have the international ICF International Contract Amendment number 6. Jonathan, you're going to present that?
Chair Edelin and members of the board, here we have a contract amendment number 6 for ICF International for his Habitat Conservation Plan consultant, and this is for completion of work through a screen check draft and then public review draft Habitat Conservation Plan. Also, I have a very brief PowerPoint presentation that was presented to the FORA Administrative Committee on September 4th, just last week. So I'll just run through the PowerPoint presentation and take questions. This particular presentation to the Administrative Committee was about the Habitat Conservation Plan governance and implementation measures that are being proposed through the Forward Habitat Conservation Plan. And just as an overview, an HCP comes out of the Endangered Species Act. In Section 9 of the Endangered Species Act, it prohibits a number of different activities, including take, which is defined as an action to attempt to hunt or harm, kill, shoot, wound a listed species under the Endangered Species Act. Section 10A, 2A of the Endangered Species Act allows take of a listed species, provided that there are certain conditions that are met. And one of those conditions is a habitat conservation plan. A habitat conservation plan is an essential component of the U.S. Fish and Wildlife Service issuing an incidental take permit to cover the take of a listed species. So in our instance, we are going forward through the process of obtaining a regional habitat conservation plan, and that general structure is laid out as the permitting agencies issue the incidental take permits, and in our case, we're going for both the federal and state permitting agencies. That the state agency involved is called the California Department of Fish and Wildlife, and the federal agency is the U.S. Fish and Wildlife Service. They will eventually issue permits, a state and federal permit to the 12 local agencies and to 1 joint powers authority. And then these agencies receive the take authorization for their covered activities under the plan. It includes habitat management activities and projects. And then for private projects, they receive certificates of inclusion, which the permittees extend their take coverage for those through those certificates of inclusion. So just an overview of the draft Forward HCP. It provides for conservation and enhancement framework for 19 special status plant and animal species and their natural communities, and roughly about half of those 19 species are currently listed as threatened or endangered species either under the state or federal act. It serves as a basis for the federal and state incidental take permit issuance and establishes covered activities for 3 general land use categories, and those categories are designated development areas, borderlands, and habitat management areas. And this is just a map of the habitat system under the current habitat management plan, which the Army has already completed, but it's also for the Habitat Conservation Plan, the same system, reserve system. It's roughly 18,000 acres on the base. And so one of the major governing agreements under the Habitat Conservation Plan is called the HCP Implementing Agreement. It's a draft agreement among the 13 permittees, the 2 wildlife agencies, and the Bureau of Land Management. It identifies each of the parties' responsibilities. For the permittees, they agreed to fund and implement the Habitat Conservation Plan, and that includes habitat preservation, managing the habitat, restoring habitat, monitoring the species, and reporting on an annual basis to the wildlife agencies. The Bureau of Land Management will fund and implement the habitat management activities on their property, and they are a cooperating entity under the HCP, so they don't receive take permits through this process. They have a direct process with the U.S. Fish and Wildlife Service, so they actually don't benefit from a take permit in the process. The wildlife agencies, as part of the agreement, provide take coverage to the permittees for their covered activities under the plan. So another agreement in this process is the Joint Powers Authority Agreement, and the draft agreement is among the 12 permittees in BLM to create the Fort Ord Regional Habitat Cooperative, and it would be the main entity implementing the HCP. And the cooperative has a number of different tasks and responsibilities to fulfill. One would be to implement the HCP and implementing agreement obligations, to secure, manage, and expend funds to implement the HCP, to oversee and monitor and report on the HCP implementation, to manage the habitat reserve system, provide Habitat Conservation Plan public information outreach, and to exercise enforcement and implementation powers, which is Section 6 of the JPA agreement. And this governing board for this regional habitat cooperative, as currently drafted, consists of 13 voting members and 3 non-voting members. The non-voting members include FORA, Monterey Peninsula Regional Park District, and the Bureau of Land Management. And the JPA agreement reserves acreage of take for the non-voting members, except BLM, which doesn't require take coverage, until all habitat acres transfer from the Army to the end recipient. Another agreement in this process is called the Mitigation Trust Recipient Agreement. And last year there was a bill called SB 1094, authored by Senator Kehoe, and it went into effect January of this year. It clarifies what the California Department of Fish and Wildlife's financial assurances requirements are. It assures that it actually defines the relationships among the habitat management area landowners, the habitat managers, the HCP endowment holders, and the financial institutions that hold the monies. In our draft HCP, we're proposing multiple habitat management area landowners, 2 endowment holders, which would be the UC and the cooperative, and 2 financial institutions, the UC's financial institution and a yet to be determined financial bank or institution for the cooperative. The agreement is currently being drafted by FORA Special Counsel. And finally, just the last piece of governance is a draft Habitat Conservation Plan ordinance and policy. It provides for the collection of the FORA Community Facilities District special tax, which funds the Habitat Conservation Plan endowments, and it describes the certificate of inclusion procedures for permittees to extend their take to third parties. This is just a diagram of the various agreements. We have the Habitat Conservation Plan on top, and then the HCP implementing agreement, which the different parties agreed to each do their parts. And then on the permittee side, they come together and form the Joint Powers Authority Agreement, and they'll also have the Mitigation Trust Recipient Agreement, which will satisfy the wildlife agencies that the money is being spent and held by responsible parties. And then on the regulatory side, the U.S. Fish and Wildlife Service and California Department of Fishing and Wildlife make their findings and issue their permits once the implementing agreement is signed. And it's called a Section 10 permit under the Federal Act and a 2081 permit under the State Act. And those permits go into granting take authorization for implementation of habitat management and covered activities through the plan. The permittees who will be extending take to third parties pass the implementing ordinance or policy, which allows take authorization to the third parties under the certificate of inclusion. And that's just the end of the presentation, so I can take any questions.
Thank you, Jonathan. Michael has a comment first.
Yes, Chair Edel and members of the board, I want to focus your attention on a few things about this presentation. Jonathan presented this to the Administrative Committee and to the wildlife agencies last week, and to a person. They indicated this presentation gave a very clear picture of the Habitat Conservation Plan and where it's going. This is something everyone in the room really should focus its attention on, because about 75% of the base is described in this Habitat Conservation Plan for varying kinds of management obligations and responsibilities. In addition, probably 100% of the base is affected by this, because once it's adopted, it really governs how the process for take permits and other kinds of permits will be allowed on the areas of the base. I'm not even really fully describing all the details here, just want you to highlight for the U.S. board members that there's a joint powers authority described herein. It's going to require all of you to pay attention, because it'll have a governing board, it'll have a voting structure. There's an implementing agreement that has obligations that says the jurisdictions will have to adopt ordinances that say you're going to comply. So there's a number of factors herein, and it's coming to the table really soon. Jonathan has done an extraordinary job in putting together an organizational chart in an attempt to put in one place a way for folks to understand how this HCP comes together. But everyone from the folks in Marina and the riparian corridor along the Salinas River to the folks in Delray Oaks and their relationship with the Regional Parks District and the Frog Pond, and how all of those areas are affected north to south and east to west on the former Fort Ord, described in this several hundred-page document with multiple agreements that require the jurisdictions to follow through. So it's on the table. Jonathan's done an extraordinary job in putting this together. If it wasn't for his cold, I think you'd even be as equally impressed as the Administrative Committee was last week.
Thank you, Michael. We'll continue to protect our frogs. Any questions or comments by yes, Tom?
So on slide number 6, it says there's 13 permittees. Slide number 7 says there's 12 permittees. How many permittees are there?
That's 12 permittees and 12 local land use agencies, which are each are a permittee, and then one is a JPA organization yet to be formed. So it's 13 total.
Thank you.
Okay. Any other comments or questions by yes, Dr. Ochoa?
Who are the permittees?
The permittees include CSUMB, Monterey Peninsula College, includes Marine Coast Water District, State Parks, Monterey Peninsula Regional Park District, the 5 land use jurisdictions, and University of California.
So that means we're going to be a voting member.
That's correct.
All right.
You're going to have a lot of fun coming up here.
I have a couple of other layman's questions. Can you just briefly define certificate of inclusion and the word take, the word you're using it in this draft ordinance slide?
Yeah. So take, it's defined differently under the Federal Act and the State Act. This is just a brief summary of the Federal Act, where they define it as an action of or an attempt to hunt, harm, harass, pursue, shoot, wound, capture, kill, trap, or collect a species. And the State Act has a slightly different definition, but it's similar in meaning. And what was the second question? I apologize.
Certificate of inclusion. I can't quite reconcile that definition of take with permittees extending take to third parties. What does that mean?
So the permits will give take coverage. So instead of the Federal Act's pretty strict on the penalties for taking a species, it's usually a fine or even imprisonment. It's a felony under the Federal Act. And so extending a take permit, they're saying certain activities will prevent those penalties from occurring, because in this case there's an exception for it. And so extending that exception to a third party is the concept.
Okay, it's the exception.
Any other questions by board members? Yes.
Just a quick
Victoria.
one. It goes to, I think, maybe jurisdiction and a comment that Michael made earlier. On one of the slides, mine aren't numbered, it says there are 3 general land use categories. One of them is designated development areas. And then you flip to the map, the next slide, and I'm just not quite sure what the map is showing. I think I know what it's showing, but it probably is not showing the designated development areas shaded.
No, it's shading the habitat conservation areas.
So my question is about the reach of the Joint Powers Authority, isn't it? It sounds like it's for basically what Michael said, almost 100% or 100%. So the shading would be maybe different shading for the different areas, which each would have to comply in different ways. Is that a graphic analysis of?
Well, so the Joint Powers Authority, as currently envisioned, would include all the owners of the habitat conservation lands. PLM has the largest portion, about 14,000 acres, and they would be a non-voting member on the Joint Powers Authority Board.
But am I misunderstanding? So that this is a habitat conservation plan that covers 3 types of land.
Right.
So there's an imaginary map in my mind anyway that would show that whoever's on this group also has some kind of say on how conservation takes place, maybe in different ways, on these different types of parcels that are not shaded here. Is that right?
So just going over to define those 3 categories in a little more detail, the designated development areas are best demonstrated by the white areas on the map. So those are the areas designated for development. A few of the habitat areas do allow some additional development. They're called development with reserve restrictions, and that includes the landfill parcel, parts of State Park, the easterly portion of State Parks, the Laguna Seca parcels adjacent to Laguna Seca out here, the youth camp and habitat. The youth camp is one of those parcels as well. I think also E5A, the Marina Northwest corner, is a development with reserve restrictions as well. Does that help address that? I mean, the plan area is the entire base. It's all 28,000 acres, but they're just split into 3 different categories: the development areas and the habitat management areas. And then borderlands are actually a part of the designated development areas. They just happen to border a habitat reserve.
So they all 3 have to have some kind of conservation plan, all 3 types of land.
Well, the plan, in essence, has a mitigation lands that will be preserved in perpetuity. That's the green areas on the map. So for that guarantee of preserving and restoring lands for habitat within the green areas, the permits will be issued for any take that occurs as you do the restoration and mitigation on the lands, and also for take within the designated development areas. So the designated development areas don't have a habitat requirement, but it's the green areas that do.
Good. Okay, any other questions by board members? Yes, Debbie?
So to elaborate a little more on the map then, the areas that are designated in whatever color that is, yellow, green, as the habitat preservation areas, what happens to activities that take place in that area? Because when I look at it, I see the Monterey Branch Line and the Balloon Spur in that area, and as well as the Fort Ord Dune State Park, which is doing various different projects. I also see the Highway 68 corridor, the Caltrans right-of-way. And so if activities take place in those areas, will they be covered by the plan? And will there be restrictions because they're in the habitat areas?
So there's a take assessment that's part of the habitat conservation plan. So it assumes by a species basis what their coverage is on the 28,000 acres. So it'll look different for tiger salamander compared to another species like red-legged frog. But there's assumption that of a certain amount of take on each of the species and their areas, and I believe it does call out areas for Highway 68 bypass in the future. I can verify that and get back to you on that detail.
Oh, okay, and also related to the branch line light rail and
Yeah, that is currently outside of Fort Ord. It's part of the Union Pacific right-of-way. So there is a small section between state parks and Highway 1 that is not part of Fort Ord. It's part of the Union Pacific Railroad right-of-way.
well, at this point, it's our right of way.
Oh, you're talking about the rail spur?
The Monterey branch line and the balloon spur.
So there's the spur, which is adjacent to State Parks property on the west of Highway 1. So that is a covered land, but then there are lands that are not part of Fort Ord. It's a very small strip to the west of Highway 1 where the railroad tracks are, and that's technically outside of Fort Ord. It's not part of the Habitat Conservation Plan.
Okay, that sounds like the former Union Pacific right-of-way, the Tampsey rail right-of-way right now.
Okay.
So that's considered outside of Fort Ord and not part of the Habitat Conservation
It
Plan.
didn't transfer through the Army, so it's not part of Fort Ord.
Oh, right. Okay.
Any other questions by board members? Seeing none, out to the public. Any questions by members of the public?
The map I have is all one color. It looks like the entire base except for a few white areas here. So it sounds like to me that the reuse plan, it will be taking a different direction under this habitat management plan. That sounds like further confusion. And if that is the case, I don't see how the local people will be involved, our organization, or anything else, because it sounds like this other powers authority will have all the say-so, will be making the decisions, will be doing the real participating, and will become the owners, is what I've heard here today, unless I'm mistaken. So I'm just, I really need to have this thing laid out, because like I said, the map I have is almost the whole base, and it's all gray. Everything is gray except for this little space right here. So I'm having a hard time trying to figure out the habitat management plan from the reuse plan and from the participation by the local community in making decisions about what is happening here.
Any other public comment? Going once? Okay, public comment period's closed. Michael, do you want to address Yvonne?
Yeah, Levon's question is one that we get quite a bit as it pertains to the Habitat Conservation Plan. The Habitat Conservation Plan is a method for implementing what has already been adopted by the United States Army in the Habitat Management Plan. The Fort Ord Multi-Species Installation-Wide Habitat Management Plan, adopted twice, I guess, 95 and 97, described in detail the protections of endangered species on the former Fort Ord. That's changed over time because it's taken a while to get this approved, so a few more species were added. But I want to make sure that Ms. Stone, three things. One, we will get you a color map. If anyone desires one, we can get a color map to give you a better idea. Number two, this was fully anticipated in the 1997 base reuse plan and in the work that the individual jurisdictions have done with their general plans since, anticipating that the Habitat Conservation Plan, which doesn't change the base reuse plan, it simply codifies approvals already in place by protecting the very best habitat on the former Fort Ord in a very definitive way and financed by the development that occurs on the former Fort Ord. And the third item, Levon, to extend this comment on does not change. In fact, as it's adopted, it implements key parts of the base reuse plan that are still under policy question, as noted in the reassessment.
Thank you, Michael. Back to the board. Any other final discussion? Yes, Ian?
Michael mentioned a number of 75%. Could you expand on that? I wasn't sure what that related to.
Well, I'm using very general numbers. We can get you specific ones, but about 75% of the former Fort Ord is either in open space or habitat. And in the Habitat Management Plan and the Habitat Conservation Plan describes how that's managed in some ways, which includes peripheral lands, which are called borderlands, which circumnavigate many of the areas. So there's a 100 to 200 foot buffer that surround these major habitat areas to the development zones. So even though it's white on the map, there are sections that are white, which are development, that are really borderlands, that are really protected areas that help to conserve areas for endangered species. So about 75% of the former Fort Ord is really described in one way, shape, or form to protect endangered species. The other 25%, much of the other 25% generates the revenue to pay for it.
Any other comments? Yes, Debbie?
I'm sorry, I had one additional question that I had forgotten about. So if the incidental take permits are issued to the 12 local agencies and the Joint Powers Authority, then those of us that own property and have development on it within the zone, and if we're developing, then do we work under the incidental take permit of the jurisdiction? Or do we have to address that separately?
Jonathan, you going to answer that? I think so too.
You would work through the jurisdiction you'll be permitting through. So if you're in the county, it would be the County of Monterey, for example.
Okay, or if we're, okay, so we would not have to go separately to fish and game, or fish and wildlife.
Right, that's, once the permits are issued, then you can go through the certificate of inclusion process.
Okay, thank you.
Any last comments? I'd entertain a motion. Or, sorry, Tom, go ahead.
So I just want to make sure we're on agenda item 10B, which is to authorize, is it an additional 98.5 to go to ICF for the 8 items listed on page 62 to 63?
That's
so
correct.
Just a question, why wasn't this included in their original scope of work, or their scope of work with, I guess, 5 previous amendments?
Jonathan, you want to answer that, please?
So we need to step back to amendment number 5 just to answer that question. So amendment number 5, the board authorized an additional $40,000 from last year's fiscal budget to approach these last outstanding technical issues with the wildlife agencies on the plan, and also used budget that had been set aside for completion of the public draft HCP, which had been in their scope to accomplish these task-specific meetings on these outstanding issues. So far, they've been able to accomplish agreement on 6 of the outstanding issues. There are still 8 that need resolution at this point. So this budget would complete this process. It's been quite a tedious process of going through all the different species and their issues on the habitat areas, in particular California tiger salamander and its treatment as endangered species. It's highly hybridized on Fort Ord, so there's some questions to be resolved there. Are all the hybrids treated as endangered species, or are they treated as non-listed species, etc.? So we're still have about 8 meetings to deal with issues from hybridization of California tiger salamander to what the baseline is going to be for snowy plover nests on the beach of state parks, and that's what's left to be accomplished. Also, this contract includes putting back in completion of the public draft habitat conservation plan, which was taken out in the last contract amendment. And then also meetings for presenting the public draft to the FORA board, explaining different pieces of that, and participation in the public review process as an expert. We anticipate at least one public meeting to present the plans to the public and seek comments during the 90-day NEPA review period, and it's a 60-day CEQA review period. They'll be at the same time going forward with both review periods at the same time. Does that help address the question?
Sort of, but let me make sure I fully understand it. So back in March, we authorized an additional $40,000 for them to complete the rest of this work. Now here we are in August, and they estimate it'll take another $98,000 to complete the rest of this work. I'm wondering if we go another 6 months forward, how much more will they ask to complete the rest of this work?
So your question is well taken. We are, at the staff level, trying to manage what the feedback we're getting from the wildlife agencies. So there are comments; they are significant from the wildlife agencies. They do have quite a bit of authority as to what they want to see in the plan. We are giving them pushback. They've actually requested things like including species that aren't currently being proposed in the plan. So we're holding the line on many issues like that. Just to address that concern, we're holding our consultants accountable for getting this done within this calendar year, and we may have a recommendation to the board to pursue more legislative tools if we need to in the future, if we have some technical issues that just can't be resolved. But we're hopeful these issues can be resolved in the next few months.
Thank you.
Chair, if I could add, just a reminder for the board, this is really not our document. In the end, it's a document that belongs to the U.S. Fish and Wildlife Service. They're the ones that publish it. They're the ones that do the issues. Under the rules and regulations for doing a habitat conservation plan, we're the ones that pay. So we're not in as much control as we'd like to be. Believe me, we push back as much as possible, but we also recognize that everyone at the table's ultimate goal is to have a document that the community will support, that will protect the endangered species and allow us all to move forward. It's not going to be inexpensive. It's already cost us well in excess of a couple of $1 million to get this far.
Yes, Gail.
If I may. I think the problem, Jonathan, is that what Dr. Moore was addressing is that it's presented to us in a contract as a task, as it's here laid out, we will do these tasks for this amount of money. So when we approved previously the additional sums for these tasks, we're assuming the task is going to be done whether that takes 10 hours or 100 hours, versus they're not presenting to us an outline that we are going to bill you for our time, which is how I bill for time. And so whether I tell my clients, and when I present a contract to them, I lay out that whatever time I expend, you're going to pay for, and I can't estimate the time. So that's the difficulty and the problem that as a board and as the public, when we're looking at this might be very money well earned, well spent, but when you're looking at a contract that lays out in task and now you're saying, wait, it's taking me more time, it's a difficult concept to swallow. So what I need to know from FORA staff is, are the services for which we've previously paid, did we pay a reasonable amount of money for those services? And going forward, therefore, are this estimate of $98,000, $98,500, is that a reasonable expense for us to pay for the services we will receive? And that's where I'm missing in this report.
That's good feedback there on the contract, and I think you'll see at the end of the contract there is they show what the hourly rate is and the estimated number of hours for the consultants on each task, and that is how we receive their invoices based on completion of tasks, but also the hourly rate. So I appreciate that feedback, and we'll make that clear in the next contract if there is a future contract amendment with this consultant and other consultants. But I believe these services that we are requesting authorization for would advance the plan and are valid tasks for them to complete.
Thank you.
Yeah, that's a good point. We'll have the executive committee take a look at the contracts, whether it should be by hour or by task or whatever else.
What are you selling?
Exactly. We need to know that before we do it. Good point. Any other comments by board members? Okay, I'd entertain a motion to authorize the executive officer to execute ICF contract amendment number 6, not to exceed $98,500 in addition to budget authority. We have a,
Approval.
okay, Mayor Gunter, or, I'm sorry, Supervisor Salinas, and second with Mayor Gunter. Any discussion on the motion? All in favor signify by saying aye.
Aye.
Anybody opposed? Motion carries unanimously. Thank you very much. Okay, next, we're winding down here to some extent, but one of the more important parts of the meeting, public comment period. Any member of the public wishing to address the board may do so now on any item not on the agenda. You've got 3 minutes. Any member of the public wishing to address the board?
Yvonne Stone, Florida Environmental Justice. What I'm concerned about is community engagement and participation. And a community is similar to a living creature comprising different parts that represent specialized functions and activities or interests, each operating within specific boundaries, though that meet the community needs. Schools focus on education. The transportation system focuses on moving people and products. Economic entities focus on enterprise and employment. Faith organizations focus on the spiritual and physical well-being of persons. Healthcare agencies is supposed to focus on prevention and treatment of diseases and injuries. For the community to function well, each part has to effectively carry out its role. Oh boy. In relationship to the whole organism. And I just don't see that happening. A healthy community has well-connected, interdependent sectors that speaks to the responsibility for recognizing and resolving problems and enhancing its well-being. Successfully addressing a community's complex problems requires interaction, collaboration, and coordination of resources from all parts. That's from its community leaders, its organizations, its local people, and all those who feel like they are a part of the community. But we certainly should not be making these decisions and saying, this is the way we feel like it should be done, whether you like it or not. And that is what I'm looking at. Thank you.
Thank you, ma'am. Any other members of the public wishing to address the board? Seeing none, the public comment period is closed. Next, we have the executive officer's report.
Yes, Chair Edelin, all of the items on the executive officer's report are informational in nature, and I do believe that we've spoke about a number of them. There is a post-reassessment advisory committee item, which is 12E, which we're asking for an action. Jonathan Garcia will present that, but on my executive officer's report, I see all of those as being information, unless a member has a question about one of them.
Frank, you have a question on
Yes, I
12E.
do on the number 12A. As all of us know on the board, there's presently litigation. I'm not going to get into details of it, but basically the outstanding receivable relating to development fees, assuming for the moment that the position of this board is accurate in that they're saying that the development fees are due upon the sale or transfer of Preston Park. Why is this considered to be an outstanding receivable at this time, since that particular act of transferring or selling it hasn't actually taken place? It would seem that to be consistent, we should be listing all land use jurisdictions' properties as accounts receivable, outstanding receivables, if we're going on that theory. So my question is, why is that now listed, since the position of FORA has been or continues to be that it is due only upon the sale or transfer? Thank you.
This is an information item, Chair, and I reviewed this with council. This is an item the FORA board made a firm decision that the Preston Park project would be put up for sale. That was a decision made over a year ago. The fact that there is litigation has deferred that sale, which council and staff and the executive committee agreed that this is really an outstanding receivable.
And I believe Jonathan has the colloquia funding request briefing.
In your packets, there's item 12E. This is the Post-Reassessment Advisory Committee, which there are two recommendations. One is to receive an update on the CSUMB hosted forward reuse issues colloquia, and second action is, or recommendation is to approve attached budget support for the colloquia event. The Post-Reassessment Advisory Committee met on August 12th and August 19th, and also this week on September 10th. And in those meetings, they worked with CSUMB on refining the program for the colloquia, and that included looking at the 4 topics that the board authorized at the July meeting. These 4 topics are economic development, design guidelines, blight removal, and the national monument as a catalyst to economic revitalization. And in a number of the meetings, there was some discussion about which kind of speakers would be wanted and what we want to hear from the speakers, and who the audience for the speakers would be, etc. These major 4 topics were also discussed about what subtopics would speakers consider we want speakers to cover during the process. So under economic development, the committee discussed subtopics of political process, attracting employers, optimizing job mix, optimizing retail, and anticipating the market. And for design guidelines, subtopics discussed were design character as an economic amplifier, the political process, balancing common design character over multiple jurisdictions, and then cutting-edge planning tools, which included the idea of using a tool called the community charrette, and form-based planning as another tool. Under the National Monument, other subtopics were a catalyst for economic recovery, how to incorporate in city and county planning, and recreation open space connections. And then under blight removal, 2 subtopics were broken windows case study and financing solutions. So to give a brief overview of how this planning is going forward is the idea is to have appropriate speakers from outside of the area primarily to come in and share their expertise in these particular disciplines and topics, and then also to, once they give initial presentation of maybe 20 minutes, to come into a panel setting, and then also have a number of questions that would be formulated for them to address that could relate to issues we may be having on forward. So that's the general concept. CSUMB has looked at dates in December. I believe December 11th, 12th, and 13th are the current dates on the calendar for looking at this event, and passing the budget would allow FORA and CSUMB to continue to work at recruiting speakers and setting up the logistics for this event. So I'll take any questions.
Okay, thank you, Jonathan. Any questions by members of the board? Yes. Graham.
Yes.
It's the December 11th, 12th, 13th. That was when this is printed. They've met since.
We're having so many meetings and so many changes, but we're flexible. Semper Gumby. Any other questions by board members? Saying none out to the public. Any questions by members of the public? Back to the board. I'd entertain a motion to receive the report and approve budget support in the amount of $56,725 for the colloquia event.
So moved.
Second.
Okay. Mayor Rubio was the primary motion maker, and Councilmember Morton second. Any discussion on the motion? All in favor, signify by saying aye.
Aye.
Anybody opposed? Thank you very much. That helps a lot. I think this will be a great opportunity, great event. Okay, next, any items from members? Yes, Tom.
Just one item. I suspect some of you have not had an opportunity since you were studying your board packet the last 2 days to note that in the Coast Weekly there was an article regarding Marina Coast Water District and the Ord community. They didn't quite get every little detail completely accurate, so I want to assure the board that Marina Coast Water District does not believe that it sets jurisdictional water allocations on the Ord community. That is the job of this particular body. So please, when you read that article, if you read that implication or see those statements in there, that is not correct. You all set allocations. Thank you.
You also sent around an excellent PowerPoint that summarized what happened there. That was really outstanding. Thank you. Yes, Ralph.
Yes, to follow on, they weren't very accurate in the reporting of developable land in Seaside either. I think they doubled it. So when they talk about efficient and precise reporting, I haven't seen any of that in a while.
If you don't want that to develop, we'll take the land if you don't want it, Ralph. Any other items from members?
Yes.
Ian.
In the same vein, I guess, I want some clarification from the executive director about what I've been hearing or reading in the paper somewhere around there is somehow casino gambling or gambling is authorized on Fort Ord. And so I think the FORA board needs to clarify that issue because notwithstanding what's going on, it's either the facts or it's not. In my reading of Fort Ord language is that's not allowable by any means, let alone some type of, let's just put it on the word, some type of initiative that's out there. We need to be able to put the facts on the table. So is that true or not true, that gambling is allowed on Fort Ord?
The history of this question goes all the way back to 2004 and was discussed at length by the FORA board in 2005 and 2006. And in 2006, the FORA board adopted a policy to preclude casino gambling on the former Fort Ord. And it was very precise to casino gambling. At the time, there were jurisdictions that had gambling off of the former Fort Ord. And there was a certain amount of concern about the type of gambling. And there was also an effort undergoing at the time potentially to move the county fair to the former Fort Ord, which would have allowed a certain kind of gambling to occur. So the language was real precise in the FORA action, which is casino gambling is not allowed on the former Fort Ord.
And is there anything in these two initiatives, and I'm talking to the election chair right there, authority, is there anything in these two initiatives that would allow that?
No.
A little equivocal about that, I guess, right? No. Okay, any other items from members? Saying none, ladies and gentlemen, we're adjourned. There's still sunlight out there. Go out and enjoy it. Thank you.